Okay, everyone, welcome back to the show, the Probate Show today. Today, we are going to do a very two difficult cases, very two difficult questions about probate. One situation is the claim of the property from the grandma and the mom on the deceased spouse. And we're gonna go through a couple of situations. This is a real life example, and the probate attorney Lung, gonna answer all the questions about that situation. The second uh, case is about living trust. We're gonna go through a couple real life example as well about the living trust. So, with that, I'm gonna introduce to you Lung. Welcome to the show again. Hi,
Hi, Lom. Thank you for hosting this show and inviting me on the show again.
always a pleasure. So there is a question that I encounter with one of the clients I have. So let me give you a basic background a little bit for this situation. This one, mm, I talked to the mom of this guy who passed away. Let's call that this is a grandma, right? So basically, the son passed away. The son doesn't have any marriage. He has a girlfriend, however, and together he and the girlfriend have two children. Now we come to a property that is owned under his name solely. So the girlfriend doesn't have any name in the title of this property, and this property already bought before they met and before they had children. Um, so in this situation, the grandma wants to sell the house. I'm sorry, the grandma wants to keep the house for his children. However, the mom wants to sell the house. So who has the right and who has the case in this situation? Huh?
Okay. So this is one of those definitely very tricky situation, and it's gonna be very fact intensive. But let me just basically go through the basic of the law before we go into the argument.
Okay.
So the by default, the Arizona state law for probate is that, and of course, if I'm hearing this right, this guy when he died, he did not leave a will, right?
No, he doesn't have any will. He doesn't have any trust.
Right. So based on the intestate statute, the person who would inherit this house would go by the following order. The first is going to be surviving spouse, but because there's no surviving spouse, this is just a girlfriend. She does not
Yep.
get to inherit the house. So
Okay.
then it goes down to the next level, which is the issue or the children in this case.
Hmm.
But the problem in this case is that the children are minor children.
Correct. Yes. Yes. It is.
So in order for the children to get this house, there has to be a guardian. The
Mm,
guardian would basically stand out and collect this house and keep it for safekeeping until the children are of age that they can inherit the house.
okay.
So
Okay.
the question of who becomes the guardian is going to be a critical question here.
Okay.
And I think you have something you want to ask me, Lam?
Right, I think you are going right into it. Like, who's gonna become the guardian for the two children in this situation?
Right. So most likely, the mother is probably going to become the guardian of the children,
The
which
girlfriend,
are
right?
the girlfriend.
Yes. Yes.
So the girlfriend is gonna petition the court in order for her to be able to take this house for the kids.
Mm.
Obviously, mother can also petition to the court that for the house not to be sold, so that way she can live in it. However, the question that the court is most concerned about is, are the children living in this house?
Mm.
Because essentially it is their house. If they were living in it, then obviously the court would allow the house to be kept as is.
Okay.
But let's say if the children goes and live with the mother,
Mm.
then what would be the purpose of keeping this house around when the children don't get to live in it,
Right. Right.
right? And
Okay.
then the court is going to allow the girlfriend to then either keep the house or sell the house and keep the proceeds for the children.
Right. And don't take the grandma wrong. I think in this situation, she's meant to like her idea is to keep the property for the children to become 18 and make their own decision instead of the girlfriend can make a decision for them now. Is there a situation that the mom, the grandma, has a case to win in this situation?
So there's two things that grandma can do that I can think of right now.
Okay.
The first, which is probably the one that grandma wants to do most, is to prove that prior to her son dying, he intended to leave the house to grandma to care for the kids.
Ah,
So
okay.
that is going to be very fact intensive, meaning she has to bring the case to the court and prove that even without will, it was his intention to leave the house to her. And that's going to be difficult without the will to prove it.
Right.
But maybe
Right.
like maybe a text message, maybe grandma has been helping paying the house. Grandma paid for the maintenance. They have been living there for a long time. These are individual, matters or facts that will help her
Right.
case.
Right.
The second that grandma can do, if she cannot do that, is to petition the court to keep the house for the children, to protect it from the mother, because the mother possibly is unfit to hold on to this kind of property. She might sell it and spend it all. She might waste it. Therefore, grandma should have the power to hold this property for the kids.
Ah, okay.
Mhm.
Okay. So it looks like as long as the purpose is to help the children, then whoever filed the petition may have the case.
Right.
The children, because that technically the house belongs to the children, right? In this situation.
Correct.
Okay.
Yeah. The difficult of
Now,
that case is that they have to start a probate as well as a guardianship and
right.
conservatorship. So you're talking about 3 cases in one.
Oh wow, wow.
Hmm.
So that is going to be time incentive and maybe cost a lot
Yeah.
for this.
Yeah, and it's
Okay.
gonna involve a lot of people, both the attorney for the grandma, attorney for the mom, the attorney for the court, and then of course the court is gonna send someone out to interview the child, or check on the family to see if they're fit to protect the child.
Got it. Now, hypothetically, if the deceased son passed away without any children, what is the situation? What is yeah? How does that look like?
Yeah. So again, we go back to the intestate statute, which
Okay.
if there is no children, then the next in line is going to be the parents. So
Okay.
obviously, in this case, grandma automatically has the right to inherit the house.
Mm,
So all she has to do is open the probate, and then she'll be able to keep the house.
I see. I see. Okay. But in this case, the children inherited the house by default, but they are not 18 yet. Therefore, they cannot make the decision. It's go back to the legal guardian, which is the girlfriend in this situation.
Right.
Okay. Yeah. Unfortunately, for the deceased son in this situation, he doesn't have any wills. He doesn't have any living trust to give the right to anyone when he passed, because he's young. That's the thing. Maybe a lot of people think that I'm young right now, I don't have to think about that. But that thing could happen every time, right?
Yeah. See, that's the problem is, when you don't have some kind of document or a trust in place, it creates all sorts of problem for the people that follow after you.
Mm-hmm. Yeah, it could be prior to his death, the mom and the girlfriend living okay together, and now obviously they have an argument about the property, and it's become a ruin of the relationship as well. So I think all the time. I mean, having at least a will. It's not as good as a trust, but at least to have a will to show what you want to do with your property is also always better.
This case actually sounds pretty familiar, because I've run into this case before. It wasn't my case, but I was asked this question where husband and wife got divorced, right? And they
Okay.
have 2 kids. And then husband suddenly passed away. I shouldn't say husband because they're divorced. So this guy passed away, and the children are minors. So very similar to this case. And the parents wanted to have that connection with the grandchildren, protect the grandchildren. But the wife came in and basically took over everything. And it's a sad situation, but the family was basically broken apart. Grandpa and grandmother didn't get to see the children anymore, because, there was tension between the mother and obviously the ex-in-law.
Yeah, of course, of course. Okay. Well, that is question number one. And I have in here, if you have any questions about your specific case, you can feel free to make a live comment here, and we will try to answer that immediately. If not, the next show is at around the same time, noon, on the first Friday of April, which is April 7th. So we'll see you there for your question. The second question that we have since last time is, in this case, both of the parents passed away. They do have a living trust. However, there are two siblings in this situation, and the sister wants to sell the house. However, the brother doesn't want to sell the house and living in the house. So how can we resolve this situation?
So in this case, because there's a trust, the first thing you want to look at is obviously how is the trust written? What is written? Generally, like when I prepare a trust, and if there's a child that the parents want to protect and wants to have that ability to live there, in the trust, I make it very clear that the house cannot be sold unless, or the house has to be kept for this child to live for the lifetime of this child, or unless the child agreed to sell it. However, sometime the drafting of the trust may not have put something like that, where it just simply saying, my property goes to my children equally, right? So it comes down to who is the trustee. If the parents pick the sister to be the trustee, she has the power to decide what to do with the house.
Okay. So the trustee is kind of the final decision maker?
Trustee is essentially I would call that person to be the manager.
Okay.
The person who manages and can control and protect the asset for the trust. So obviously the discretion goes to that person to choose what is best to do with that property. But the brother, of course, the brother can also petition the court to stop the sale, but he needs to bring up a legitimate reason as to why his interest would override the decision of the trustee.
Right.
And
go ahead. Finish your thought, and I'll ask additional question.
Yeah. And of course, it goes down to the intention of the trust. When the parents created the trust, what was their intention? Was it to let the daughter decide to do whatever she wants with it, as long as both get the money equally? Or did they really want to take care of this brother that wants to live in this house?
Okay. My question was like, is there a situation that there is actually more than one trustee? And if so, what happened in that situation?
Yeah. So in the situation where there are co-trustee or multiple trustee, then the decision has to be made with both trustee consenting. So in this case, let's say a brother and sister were the co-trustee, right? Sister can't just sell it unless the brother agreed to it. Because he has as much power as she does. Okay.
So they have to come up with an agreement before anything can move forward.
Right.
Okay. So it seems like having a trust is not the end, right? It seems like there's a lot of wordings, there's a lot of statements and terms and conditions that a person have to put into the trust to specify what exactly he or she wants to do when they pass away, right? So it seems like it's not simple using a template form to do it, but rather using an experienced attorney to set everything up is much better.
Yeah. So that goes back exactly what you were saying, Lum, is that having a trust alone is not the end. The value of the trust is in what is in it. That means the person who drafted the trust is the key important factor. Did this person interview the family enough? Did this person was able to foresee all the possible consequences or possible situation that could happen and drafted a trust so well that it protect the family, not just today, but 20, 30, 40 years from now. So that
Yes.
requires the drafter to be able to talk to the family and be able to put that into words.
Right. Right. That's why an experienced attorney gonna be able to help guiding. Okay, what is the situation? Because we have more experience to think of all this possible, not all, but more possibilities that could happen for a family situation, right?
Yeah, because obviously nobody's able to foresee everything that could possibly happen.
Right.
But if you can put in place conditions that might eliminate most of the situation that could happen, it makes for a better trust.
Right. Correct. Okay, that makes sense. That makes sense. Um, so yeah, I think that is a very valuable questions. I mean answers that you give to the audience. And by the way, if you do, like I said again, another questions, you may be comments directly here or send it directly to me on Loom, and then we're gonna respond, answer your question in the next show. Okay. Um, I think you have a situation for us um, the, um, about the person passed away that one, but disinherit the spouse, right?
Oh yeah.
Only to
So
talk about that.
so this is a particular situation where, let's say, husband and wife, they're married. Maybe this is their second or third marriage, and husband for some reason did a will but did not leave anything for the spouse. I'm sorry. Give me one moment. Sorry, Long.
No, that's okay.
I'm at my parents' house though.
Okay. Yeah.
But anywho, well, I was saying, so this is a protection that the statute provides for the surviving spouse in the event that they get disinherited by their spouse. And if the spouse pass away, the will disinherit the spouse and what happened, right? So
Mm-hmm.
this is called, it's an allowance and exempt property. So the spouse is entitled to this homestead allowance of $18,000. Oh, go ahead.
Let me interrupt you a little bit. And what do you mean by disinherit the spouse? I thought that in Arizona, right, that the property is owned by both spouse equally. Can you
Uh,
tell a little more about that disinherit spouse?
so this is a unique situation where, let's say you just married this person and it hasn't been that long, but prior to
Uh,
marriage, everything was owned by one spouse and not the other, where everything was basically separate, where one of the spouse came into the picture but didn't really have anything.
okay.
And the
Okay.
spouse is being taken care of by this other wealthier spouse. So let's say there's a rich spouse and then there's a poor spouse.
Okay.
The rich man goes out and marry this woman. She doesn't have anything, right? All of a sudden he passed away. But in his will, he leave everything to his kids. So now the
Oh.
kids tell the new stepmother, I'm sorry, but you got to get out of the house. You know, dad passed away. You don't get anything. Right?
I see. Okay. So this is a situation that basically the spouse, the deceased spouse, own everything under his name, right?
Right.
This is not a community properties owned by the both spouses. This is just a sole property owned by a deceased spouse, and he can make that decision to not giving the surviving spouse anything, right? Okay, so we have the basic understanding of the situation. So you go ahead forward.
Yeah. So even though the spouse is not supposed to get anything in this case, but
Okay.
the law do provide a little bit of protection for the spouse.
Okay.
And that protection is called allowance and exempt property. Um, So the spouse, they get this homestead allowance of $18,000. And then
Okay.
the spouse also get an exempt property allowance up to $7,000. And
Okay.
exempt property is basically any other property excluding the house.
Okay.
And then of course there's also a family allowance which provide for the very basic needs during the administration of the probate, which generally lasts about a year. So
Uh-huh.
during that time, the spouse can ask for about up to $12,000 for that year per year.
Okay. Okay.
So together, if you add all that together, the spouse can potentially get up to 37,000,
Seven.
even if the spouse got disinherited.
Okay. So 12,000 is a family allowance. 7,000 is personal property. And 18 is a like
It's a
real property.
it's a homestead. Basically, it's gonna comes out of the house.
Oh, okay. Now is that per house, or is it one
It,
allowance? Okay.
it's just a one amount. Yeah.
Oh, okay. Got it. Okay.
So
So
even if
maximum.
so it's a maximum. Even if that's $1 million, she can't get any more than that.
I see. Even he has two different houses, three different houses, more than once. Then but the surviving spouse only have one allowance to the
Right.
maximum of 37,000.
Yeah.
Okay. Okay. So it's still not a lot compared to the value of the properties, to the real properties or personal properties, right? But at least there are some amount that the surviving spouse could claim on that situation.
Right. And this is also important in situation where the creditors, basically, there's too much debts for the estate that if they were to pay it off, there would be no money left. So this kind of law also protects the surviving spouse in that she gets to keep a certain amount of money so that she doesn't have to pay everything to the creditors.
Okay, got it, got it. Okay, so if you are in that situation, right? Obviously, don't think that you don't have anything. Just make the case to the court and follow what Attorney Long just said. You potentially can claim up to 37,000. Even technically, you cannot inherit anything from the deceased spouse.
Right.
Talking about sole property, I think a lot of people, like for example, when they buy a property, right? Because for any reason, one of the spouse cannot be on the loan with the other spouse, and therefore by default they just do okay. Maybe only one person be on the title of the property. Uh, in that situation, if the deceased spouse who is on the title passed away, the house does not automatically go to the surviving spouse, right?
Correct. You probably know this as a realtor, but generally when you go to title and if you're trying to just get the house for one of the spouse and not the other, the title generally requires the spouse to sign a disclaimer.
Right,
And that
right.
is a very powerful document. By signing a disclaimer, you are giving up rights in that house. You're not allowed to get anything from it.
Yeah, yeah. Okay. Yeah, because I think the other spouse just simply think, oh, I am his or her spouse. If something happened to him or her, I still be gonna be able to get the house anyway, right? But it's actually not true. But maybe, right? If the surviving spouse go through the probate courts, then is there a chance that they can get back the property?
They can, but it comes
Okay.
down to obviously present the facts to the judge to convince the judge that this was not done intentionally by the spouse, or by the
Right.
deceased spouse.
Right. Right. So it's like case by case basic, and it's create more difficulty in that situation.
Yeah.
Okay. I think that would be concluding our show for today, and thank you so much again for being with me and helping answering all the questions that the people have. Like I said, again, the next show that we have is going to be at noon on the first Friday of April. So hopefully we can see you there again. If you have any additional questions, feel free to send it over to me, and we will be able to answer your question in the next show. All right, thank
Absolutely.
you.
I look forward to hearing all the questions and hoping I can answer most of it. As you know, there's always a new situation that arises. So I try my
Of course,
best.
of course, yes. All right. Thank you, everyone. Thank you, and have a good day, both, everyone.
Thank you, everyone.